for a bond violation hearing. I've reviewed the allegations with Mr. Tolliver. He understands those, understands he does have a right to have a hearing.
Notice how the defendant is choosing to waive his hearing? That means the court won't have to prove the allegations. He's basically saying, I admit it up front. It's a huge decision because it removes the chance to argue his side later.
First things, did you go over this violation document that lists all of the allegations against you?
Yes, ma'am.
Okay, and you understood that?
Yes, ma'am.
And you had a chance to speak with Mr. Fanto about it?
Agreed.
All right, and then you went over this bond violation arraignment and advice of rights form?
Yes, ma'am.
And did you understand all your rights?
Yes, ma'am.
And did you sign the back?
Yes, ma'am.
So you understand if you have a hearing and you waive the hearing, there will be no finding if you admit guilt, right? We're not going to have a hearing to determine guilt. You understand that?
Yes, ma'am.
Okay. And then are you waiving that right?
Yes.
All right, sir, to the allegation you failed to appear for drug testing on November 29th, how do you plead?
Guilty.
To the allegation you failed to attend individual therapy at the Guidance Center during the month of November on November 12th and November 26th, how do you plead?
Guilty.
To the allegation you failed to comply with peer recovery services through GrowthWorks as directed, how do you plead?
Falsifying logs is serious business in a treatment court. The judge relies on these documents to track progress, so this isn't just a technical violation, it speaks directly to honesty and accountability.
Who threatened you or promised you anything to get you to plea?
No.
All right, I'll accept the plea as knowing and voluntarily given. Mr. Fanto?
Your Honor, I've gone over the recommendation of Mr. Hoskins. He has, he indicates that.
Mr. Tolliver.
I'm sorry. I apologize. And Mr. Tolliver understands what the recommendation is. He does indicate, in spite of everything, that he feels that the program is beneficial to him. He does understand that his priorities towards participation need to change. And I would ask the court to consider something more along the lines of 30 days in custody with returning to the program.
Here's a glimpse into how courts try to balance strict enforcement with rehabilitation. Giving a day to get affairs in order may seem small, but it's actually a calculated move to increase the chance of compliance while still holding the defendant accountable.
All right, anything, Ms. Grasso?
We have had, conversations multiple times about making sure that he's attending his testing. He's used the airplane journal. We've done all of that. We've also had multiple conversations about him making sure that he's attending his meeting, including peer recovery, and he reported that he was. It seems that when he did attend, it was for 10-15 minutes, and then he would log out.
Of what?
Of the peer recovery.
Okay. Well, we had and now we have meetings that were falsified. Are those the ones with peer recovery?
Yes.
Where he would just log in and log out?
Or not at all.
I mean, Mr. Tolliver, I knew we had some challenges with you coming in, but I can't, everybody in this program, it's so onerous. It's hard. And everybody has to follow the orders of the court. You have a second drunk driver.
The judge is stacking the violations: prior DUIs, failed sessions, falsified logs. This isn't just a pattern, it's a red flag showing that the defendant hasn't engaged seriously with the program. Courts take repeated offenses very seriously.
And it's non-compliance, right? It's not necessarily use, but it's that we can't get you to make progress because you don't show up for things. And I can't have someone in the program that doesn't show up. And we had a staff meeting. You've come up multiple times at staffing since you've been in orientation in the program about how do we make this work for you, given, everyone's circumstances are different in a treatment program. And we just can't I mean, we can't figure anything out because, it's not about what you need, it's about who you show up. And I've got falsified logs. I mean, it's court supervised treatment. You've not done treatment in a month. You've not done anything at peer recovery services. You not show up for testing, and you're not, going to your meetings the way you're supposed to. And I mean, Mr. Tolliver, if I can't get you, these are showing up is easy. That's the easy part. And if I can't get you to do that, I don't see this program working for you.
This is the heart of the drama. The judge isn't angry for no reason. She's frustrated because the system is designed to help, but it only works if the participant shows up. When compliance is missing, the whole program's integrity is at stake.
Shit, I'm so sorry. I haven't touched anything since I went to rehab. I've been trying my best. I have been to try to be on time and not miss things. I've been really trying. I promise you that.
I know, but you have to try, I understand that, but I can't, how do I have a successful program or a program with integrity if I just okay, we'll keep you. You're not doing any of the things. What were the last violations? You didn't appear for drug testing. You didn't show up for alumni. That isn't when did he get on bond conditions?
I believe he's on bond conditions 3 months.
September, does that sound right? September 3rd?
Yeah, I do believe so.
Yep, we set treatment court bond conditions on September 3rd.
I mean, I'm
Failed to attend 3 pro-social meetings, failed to appear for testing, failed to attend IOP. Did he finish IOP?
Not yet.
I got 3 days left, and the main reasons why I went to IOP was because I had a major violation or probation date with her. I think there was one day I couldn't make it because my ride didn't make it. Or they didn't go themselves, so I couldn't get a ride there and make it in time.
But there are compliance issues over and over and over. And at some point, we're expending resources. And, I remember your violation, one of the last ones, and you were like, oh, well, I didn't have a ride. And it's not that is your problem. That is your responsibility.
I understand.
And you're not taking it seriously. You missed both of your therapy appointments in a month. Were those the only 2 we had?
Yes.
You didn't go to therapy for a whole month. You've only been in the program 3.
Mm-hmm.
Why?
I forgot. I know I'm supposed to prioritize and put them down on his calendar and stuff like that. I forgot. I mean, there's no other way to explain it.
Jeff and Kara, can I see you in the back? I just don't see you successfully completing this program. I just don't. Because I know, I hear you, but the lack of compliance so far is it's really not good.
I know it looks terrible.
It doesn't look terrible, it is terrible. And that's the issue is I can't, when we take someone in the program, I'm only one person. I mean, we have a stop. I can't take new people in because I have too many people. And this is a space that someone who needs it and will do the work, will show up, is not available for. And I mean, I just don't see an alternative at this point. You're still on bond after 3 months because we can't get you to comply enough for us to admit you into the program. And it's it's alarming. So I'm not going to allow you in the program.
And just like that, it's a turning point. He's denied entry and faces 120 days in jail. This moment shows how consequences catch up when rules aren't followed, even in a program meant to rehabilitate. What would you do in his shoes?